The marble chamber of the Supreme Court held 400 souls in absolute silence. Not the polite quiet of formal proceedings. Not the reverent hush of legal ritual. This was the silence of shock, the kind that follows lightning before thunder arrives. Congresswoman Jasmine Crockett stood at the council's table, a leather folder open before her, her voice cutting through the tension like a surgeon's blade through diseased tissue. "The framers of the 15th Amendment," she said, her gaze locked on Justice Samuel Alito, "would recognize exactly what is happening in Jefferson County today." She paused. The courtroom seemed to lean forward as one organism. "The question before this court is whether we have the constitutional courage to see it as clearly as they did." Justice Alito's jaw tightened, his knuckles whitened against the dark wood of the bench. Cameras positioned discreetly in the press gallery captured everything: the frozen expressions of 8 justices, the collective intake of breath from the gallery, the singular moment when constitutional law, political reality, and moral clarity collided with volcanic force. What had happened in the preceding 30 minutes hadn't just silenced one of the court's most combative justices. It had exposed a truth about American democracy that would reverberate through courtrooms, newsrooms, and voting booths for a generation. This is that story. Jasmine Crockett had never intended to become a symbol. She had built her career in the shadows of the legal system, a public defender in Dallas, representing clients the system had already convicted in its mind. She won cases everyone said were unwinnable, not through theatrics, but through meticulous preparation and an unshakable belief in the Reconstruction Amendments. Those 3 constitutional provisions, the 13th, 14th, and 15th, were America's second founding, she often said. They weren't footnotes to the original Constitution. They were corrections, expansions, promises written in blood that this nation would become more than its founders had imagined. After years defending the vulnerable, she turned to civil rights litigation, specializing in voting rights. Then came Congress, a platform she never sought but accepted when her district called. Even as a congresswoman, she maintained her law license, arguing cases of exceptional constitutional importance. Like this one. Johnson v. Texas challenged a voter identification law that had disenfranchised 53,000 eligible voters in Jefferson County alone, 83% of them minorities, despite minorities comprising only 34% of the population. The numbers told a story. The law, ostensibly neutral, functioned as a modern poll tax. Across the bench sat Justice Samuel Alito, appointed in 2006, architect of some of the court's most conservative decisions. Brilliant, combative, unapologetically originalist in his philosophy. But lately, something had shifted. In speeches before the Federalist Society, at private donor dinners, in off-the-record conversations that inevitably became very much on the record, Alito had been making increasingly pointed comments about voting rights. The framers understood that voting procedures needed safeguards, he'd said 3 weeks prior at a gala in Northern Virginia. Modern attempts to characterize basic security measures as discrimination would have puzzled them. Legal ethics experts had filed complaints. The Supreme Court, uniquely among federal courts, had no binding ethics code. The complaints went nowhere. But Alito's public statements created an impossible situation. How could he fairly judge a voting rights case when he'd already broadcast his views to the world? Crockett had anticipated this. She'd spent months not just preparing her legal arguments, but researching the historical record that Alito claimed to revere. She'd found something the justice wouldn't expect. As the morning of oral arguments arrived, Washington buzzed with anticipation. The court had granted extended time, 90 minutes instead of the usual hour, acknowledging the case's magnitude. Protesters lined the Supreme Court steps, holding signs reading, "Protect the vote," and "States' rights aren't absolute." Inside, every seat was filled. Senators, civil rights leaders, constitutional scholars, reporters who'd covered the court for decades, all waiting to see if Crockett could withstand the judicial onslaught that had broken lesser advocates. No one expected what was about to unfold. "Mr. Chief Justice, and may it please the court." Crockett's opening was textbook perfect. Confident, measured, human. She began not with abstract legal theory but with flesh-and-blood consequences. "The right to vote is the foundation upon which all our other constitutional rights rest. When 53,000 eligible voters in Jefferson County were prevented from casting ballots last November, we witnessed not just a tragedy for those individuals, but a constitutional failure." Several justices nodded. Justice Sonia Sotomayor leaned forward slightly, signaling engagement. Crockett pivoted to doctrine. "The state argues that Article 1, Section 4 grants it unlimited power in establishing voting procedures. However, this ignores both the 14th Amendment's equal protection guarantees and the historical context in which the text of Article 1 is quite clear." Justice Alito's interruption came 90 seconds into her presentation, his tone carrying the dismissive edge of someone who'd already reached his conclusion. "The Constitution gives state legislatures primary authority over election procedures. Isn't your real quarrel with the constitutional design itself?" Several observers exchanged glances. Interruptions were common in oral arguments, but this one felt premature, almost personal. Crockett didn't flinch. "Justice Alito, I'm not quarreling with the Constitution, but rather offering a complete reading of it. Article 1 does not exist in isolation from the Reconstruction Amendments, which fundamentally change the relationship between federal and state authority over elections." She continued methodically, building her case brick by brick. The 14th Amendment's Equal Protection Clause, the 15th Amendment's explicit prohibition on racial discrimination in voting, the Reconstruction Congress's clear intent to federalize protection of voting rights. Justice Elena Kagan nodded appreciatively. Justice Ketanji Brown Jackson scribbled notes. But Alito wasn't finished. "These are merely inconveniences, counsel, not constitutional violations," he interjected again, his voice hardening. "Every election regulation imposes some burden. Unless you can show deliberate discrimination, which your evidence fails to do, these policy choices belong to state legislatures, not federal courts." The counsel was pointed. He was drawing a line between Crockett the lawyer and Crockett the politician. She refused to take the bait. "With respect, Justice Alito, this court's precedent in Anderson v. Celebrezzi and Burdick v. Takushi established that even without discriminatory intent, regulations that significantly burden the fundamental right to vote must be justified by substantial state interests. The evidence we've presented demonstrates the state's interest in preventing fraud is self-evident." The third interruption came like a hammer blow. Alito leaned forward, his frustration now visible to everyone in the chamber. "The Constitution does not guarantee convenience, Congresswoman. It allocates authority, and in this context, that authority belongs primarily to state legislatures." Congresswoman, not counsel, not Ms. Crockett, a deliberate emphasis on her political role designed to undermine her credibility as a legal advocate. The gallery stirred. Several justices, Roberts, Barrett, Kagan, exchanged subtle glances that communicated discomfort with their colleagues' breach of protocol. But Crockett had been waiting for this moment. She closed the folder in front of her, then reached for the leather portfolio she'd kept sealed throughout the argument. The room seemed to sense something shifting. "The Constitution, Justice Alito, is not merely about allocating authority," she said, her voice calm but carrying new weight. "It's about constraining it to protect fundamental rights." She opened the portfolio and removed a single document. "But since you've raised the question of constitutional design and original understanding, I believe the historical record merits closer examination. Every person in the Supreme Court chamber understood they were witnessing something extraordinary." Crockett held the document as though it were Holy Writ, which in constitutional terms it was. "Justice Alito, You've suggested several times today and in recent public appearances that the original understanding of the Constitution grants states nearly unlimited authority over voting procedures. Her tone remained respectful, but there was steel underneath. However, I have here the congressional debate transcripts from 1869, when Congress was considering the 15th Amendment. She lifted the document, its pages marked with highlighted sections. Senator Oliver Morton, a principal architect of the amendment, explicitly stated that its purpose was, and I quote, to place the power of protecting the right to vote in the hands of the federal government, where it rightfully belongs, rather than leaving it to the legislative discretion of states which have shown themselves unworthy of this trust. The chamber went completely silent. Justice Alito shifted in his seat. Chief Justice Roberts leaned forward. Crockett continued, her voice gaining momentum. Furthermore, Representative James Garfield, who later became president, stated during these debates that the time has come to establish a constitutional principle that will override all state regulations that burden the exercise of the franchise on account of conditions not inherent to the act of voting itself. She turned to a second page, her preparation evident in every gesture. Most relevant to our case today, Senator William Stewart, who drafted much of the amendment's language, specifically addressed whether states could impose procedural burdens that would effectively nullify the right to vote. She quoted directly, "We are establishing not merely a negative prohibition against explicit racial barriers, but an affirmative principle that the right to vote must be practically accessible to all citizens, regardless of station." Crockett handed copies to the clerk for distribution to the justices. Several, Kagan, Jackson, Barrett, immediately began scanning the documents. "These are not obscure sources, Justice Alito," Crockett said, her voice steady and clear. "These are the explicit words of the very framers of the Reconstruction Amendments, the same constitutional provisions you've cited repeatedly today." She paused, letting the weight of evidence settle. "They directly contradict the narrow reading you've advocated both in this court and in your recent public appearances." Justice Alito's face tightened. His hand moved toward his microphone, but before he could speak, Crockett pressed forward. "The historical record is crystal clear. The Reconstruction Congress specifically intended to limit state discretion over voting procedures precisely because they recognized that seemingly neutral regulations could be weaponized to undermine the franchise." Her voice rose slightly, not in anger but in moral clarity. They did not merely prohibit explicit discrimination. They established an affirmative federal interest in protecting meaningful access to the ballot. Now she connected history to evidence. In Jefferson County, 83% of voters turned away under this law were minorities, despite minorities comprising only 34% of the population. This statistical disparity alone would have outraged the framers of the 15th Amendment, who explicitly rejected the notion that states could use procedural mechanisms to accomplish what they could not do directly. Justice Amy Coney Barrett, who had been silent throughout, finally spoke. "Congresswoman Crockett, these historical sources are compelling. How would you have us apply them to the standard of review in this case?" It was the opening Crockett needed. "Justice Barrett, thank you. These sources demonstrate that when reviewing voting regulations, this court should apply heightened scrutiny whenever a law results in significant disparities in ballot access, regardless of provable intent. The Reconstruction framers understood that the right to vote is preservative of all other rights and requires special protection from procedural obstacles." Justice Alito made one final attempt to redirect. "These are interesting historical footnotes, counsel, but they don't override the plain text of Article 1, which remains—" "With respect, Justice Alito," Crockett interjected, her voice cutting through his, "these are not footnotes." She let the words hang in the air. "They are the authoritative explanations of constitutional meaning by those who wrote and ratified the amendments. and they directly address the relationship between Article I powers and the later amendments designed specifically to constrain those powers. She gathered her materials, preparing for her conclusion. The Reconstruction Amendments fundamentally altered our constitutional structure, creating new limitations on state authority precisely in the context of voting rights. To read Article I as though these amendments don't exist is not textualism or originalism. She paused, her gaze sweeping across all 9 justices. It's selective constitutionalism. The phrase detonated like a controlled explosion. Law clerks in the back rows visibly reacted. Justice Clarence Thomas, who rarely spoke during arguments, raised his eyebrows. Justice Alito sat motionless, his expression unreadable. Chief Justice Roberts, recognizing the historic nature of the moment, extended Crockett's time by 5 minutes, a rare concession that signaled the entire bench understood they were witnessing something extraordinary. Crockett used the extra time to methodically connect historical intent to contemporary evidence, demonstrating how Texas's voter ID law imposed precisely the procedural burdens the Reconstruction framers had sought to prevent. As her time expired, she delivered her final line, the one that would echo through legal history. In conclusion, this case is not about convenience versus security, as some have framed it. It's about whether we take seriously the constitutional commitment made in the Reconstruction Amendments, a commitment to ensure that the right to vote remains meaningful for all citizens, regardless of their race, wealth, or status. She closed her folder. The framers of the 15th Amendment would recognize exactly what is happening in Jefferson County today. The question before this court is whether we have the constitutional courage to see it as clearly as they did. A collective gasp swept through the chamber. Not loud, but unmistakable. Justice Alito sat frozen, the historical evidence having demolished not just his questions in this case, but the entire intellectual framework he'd been building publicly for years. Crockett gathered her materials and returned to her seat. The Supreme Court chamber remained in stunned silence, absorbing a rare moment when constitutional history, legal argument, and moral clarity had aligned with devastating precision. The legal and political earthquake that followed Crockett's oral argument reshaped American constitutional discourse overnight. Within hours, the video, recorded by C-SPAN and excerpted across social media, went viral. The Crockett at SCOTUS trended worldwide. Her final line became a rallying cry, printed on signs at voting rights demonstrations from Atlanta to Phoenix. Legal scholars from across the ideological spectrum praised her methodology. Harvard Law professor Lawrence Tribe tweeted, "In 30 years of studying Supreme Court arguments, I've never seen an advocate so thoroughly dismantle a justice's jurisprudence with his own claimed method, originalism. Even conservative commentators who disagreed with her conclusions acknowledged the power of her historical research." The Federalist published an essay titled Crockett's Challenge: Why Conservatives Must Reckon with Reconstruction, acknowledging that originalist methods required intellectual honesty about evidence, even when uncomfortable. Behind the scenes, the court's dynamics shifted dramatically. Justice Alito, faced with the historical record Crockett had surfaced, found himself isolated. In private conferences, several justices, including Barrett and Chief Justice Roberts, referenced the Reconstruction-era sources, asking whether the court had been too deferential to state authority in recent voting rights cases. 3 months later, the decision came down, 6-3, with Roberts writing for the majority. When voting regulations result in demonstrable disparities in access to the franchise, Roberts wrote, courts must apply heightened scrutiny to ensure that the state's interests are both compelling and cannot be achieved through less burdensome means. This standard flows directly from the original understanding of the Reconstruction Amendments, which fundamentally altered the constitutional balance between state discretion and federal protection of voting rights. Most shocking, Justice Alito wrote a concurrence, not a dissent. While maintaining that states retained significant authority over elections, he acknowledged the historical records surrounding the Reconstruction Amendments more fully illuminated in this case than in previous litigation, establishes meaningful constraints on that discretion when regulations significantly impact ballot access. It was a remarkable retreat, and everyone knew Crockett's research had forced it. Nina Totenberg of NPR called it the most significant recalibration of voting rights jurisprudence in a generation. For Crockett, the victory extended beyond one case. Law schools reported surges in applications from women of color, many citing her Supreme Court appearance as inspiration. Voting rights organizations across the country used the Crockett method. Rigorous historical research combined with statistical evidence in dozens of subsequent cases. 2 months after the decision, the Supreme Court announced its first-ever binding code of conduct, including stricter limits on public speeches by justices. Though no justice commented directly, the timing spoke volumes. In Jefferson County, voter turnout in the next election increased by 34%. Many first-time voters specifically cited the Crockett case as their motivation for participating. This wasn't about partisan advantage, Crockett explained in a PBS interview. It was about ensuring our Constitution fulfills its highest purpose, protecting the fundamental rights of all citizens, especially the right that preserves all others, the right to vote. When she returned to argue another case 2 years later, the atmosphere was markedly different. Justice Alito engaged respectfully. Other justices referenced her previous historical research. The court's entire approach to voting rights had been transformed. Constitutional law professors began teaching the case as a turning point, emphasizing that Crockett's contribution wasn't just winning, but recovering a more complete understanding of what the Constitution means. She hadn't just defeated an argument. She had recovered a constitutional vision that had been obscured for too long. Late one evening, months after the decision, Jasmine Crockett sat in her congressional office, reading letters from voters who'd cast ballots for the first time because of her case. One, from an 83-year-old woman in Jefferson County, brought tears to her eyes. "I was turned away in 2022, but last month I voted for the first time in my life. Thank you for reminding them that my voice matters." Crockett had never sought to become a symbol. She'd simply prepared thoroughly, believed deeply in the Constitution's promises, and refused to be intimidated by power. But symbols, she'd learned, aren't chosen. They're forged in moments when principle collides with authority, and principle refuses to yield. The framers of the 15th Amendment had written their ideals in the shadow of civil war, believing that America could become more than it had been. They'd created constitutional tools designed to constrain state power when it threatened the franchise. For generations, those tools had been dulled by narrow interpretation and selective history. Crockett hadn't invented new law. She'd recovered old promises. And in doing so, she'd reminded a nation that courage isn't the absence of fear. It's the willingness to speak truth even when the entire power structure of the government sits in judgment above you. Her final line still echoed in courtrooms and classrooms across America. The question is whether we have the constitutional courage to see it as clearly as they did. It wasn't just a challenge to 9 justices. It was a challenge to every American still working to fulfill the Constitution's most fundamental promise: that in this democracy, every voice matters, every vote counts, and no procedural barrier should ever stand between a citizen and their franchise. If this story of constitutional courage moved you, share it, because democracy isn't self-executing. It requires witnesses, advocates, and citizens willing to demand that our highest ideals become lived realities. Subscribe for more stories of truth confronting power, because in the end, that's the only story that matters.